Mr. Chairman, would you like me to move the minutes for, I'll move the adoption of the minutes for purposes of discussion.
Second, I need a second.
Second.
Discussion? Ted, you could say something, can't you?
Yes. The second, the motion.
Okay. No, we're in discussion now. Anything to discuss?
Got anything wrong with the minutes?
Frustrating, isn't it?
All right.
Is everyone reviewed on, this is the minutes for June 29th? Okay. If they're all reviewed?
All in favor?
Aye.
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 Oppose?
Aye, aye, aye.
Oppose? None.
I'm abstaining because I was not at that meeting. This is Amy Berquist.
So it's passed. All right, move on. Teams, regulation and discussion. Did everyone get a copy of Julianne's regulations or proposed regulations for teams for advertising? Everybody gone through it? There was some good things also. We got a few days before about real estate team survey. Also, Arello's Law and Regulations Subcommittee report on teams. Everybody got that and looked at it?
I got mine online. I did ask for hard copies, but it hasn't arrived yet, so I just have to deal with the material that was sent online.
Yeah.
Oh, I'm sorry. I mailed it out to you on Monday, Miss Vance. I'm
Oh,
sorry.
that's okay. I know what happens. Mail from Hartford always takes forever. So maybe in the future you could mail me hard copies earlier.
Definitely will.
Thank you.
No problem at all.
Julianne was going to try to be here today, but she wasn't feeling well, so I wasn't sure if she was going to make it or not. Obviously, there are questions that we have, that I have, regarding her proposal. Does anybody have any questions you want to discuss a little bit beforehand? I'm going to have to probably put this on hold till we have a chance to discuss this with her. Joe, did you get a chance, by the way, to review all this? Did you have any comments to make on the proposal and the regulations? Julianne, can you hear me?
Excuse me, you're talking to me, or did you say Joe or Jill?
Jill, I'm sorry, Joe.
Sorry, I didn't hear that. I'm just using my speaker on my laptop here. My headset's not working. Yeah, we worked on it together, but as I was reviewing it again, I mean, there was the last section, number K, on the second page, the very last paragraph. Just thought that need to be a little bit more clear for identifying words that shall not be used, and trying to clarify that the broker, designated broker, is responsible for the teams, that the designated broker should oversee the teams. I think that needs to be clear.
Right, I did notice on K also, my feeling is adding to some of these, not only limited to a partnership, partners, agency, realty, add also real estate and also realtor. These are also terms that are misused.
What about group? We see group a lot as well.
Group a lot,
If
yeah.
you're adding those others, I would add group as well.
Mm-hmm. Okay.
And for the record, Jill Conklin, I also, what you said, Ben, brokerage, broker, also real estate, realtor, company, corporation,
Right.
LLC, LP, because those are things that a salesperson might try to open a legal entity and go that route. because there's been I've had some questions regarding that. If a salesperson can register a legal entity with the state of Connecticut and work under a broker and collect their commission through that legal entity. That's been popping up. I probably had 4 times in the last couple months.
Bill, I mean, I don't know. Do you guys want me to pipe in or no?
Yes.
Yes, I do.
This is Kelly. You know, the law specifically speaks under licensing to the fact that a legal entity can only be utilized for the purpose of real estate, engaging in real estate by folks that qualify. So you have to look under licensing and look at the qualifications to obtain a legal entity license. So if you go back, first it says that any legal entity engaging in real estate, you know, under the term engaging in our statutes for a fee or other valuable consideration, must obtain a real estate license. So then you look at under licensing, it specifically spells out how a legal entity qualifies to obtain a license. It must be at least 51% broker owned and operated. So that right there tells you that a salesperson without a broker owning and operating at least 51% of the entity cannot have a legal entity. And therefore a broker may only pay a licensed individual. Now, if you a licensed person, if you look under the definitions in licensing, under definitions 2311, what is a person? A person is considered a legal entity or an individual. So therefore, a broker can only pay a legal entity if that legal entity is actually licensed. So to answer those questions, no, a salesperson on their own cannot obtain a legal entity and be paid a commission to a legal entity if that legal entity is not licensed. And a salesperson doesn't qualify to obtain a license in their individual name pursuant to, you know, by themselves, pursuant to the law.
And Kelly, you're saying salesperson, but what if it's a broker working under a designated broker?
Sure, but they can only be paid to the legal entity if they hold a license in the name of the legal entity, because a broker cannot pay a commission to an unlicensed person. So an entity that's not licensed would be considered an unlicensed person. So yes, a broker who happens to be working under another broker could certainly get a license in the name of the legal entity. But again, that's how they have to advertise themselves. And now it goes back to advertising. So they've got to advertise themselves as a legal entity working for this other broker who may be a legal entity. So it gets a little messy, but they certainly could as long as they follow the guidelines for advertising and licensing.
And I have a question. This is about teams. I didn't understand quite why we didn't use the concept teams such as New York did.
I'm not sure.
I can't answer that. Maybe Paulette can, or, you know, I'm not with the department. I was just trying to clarify the whole entity thing. I don't know what's happening with teams.
So Ted, so what exactly is your question?
This is about teams, right?
Uh-huh.
This is our way of answering, requiring, making sure that the teams include the name of the broker and all that. I'm just wondering, when you look at New York, what New York is telling me, they talk about teams. And they define teams and they say, this is what teams can do, what they can't do. I was just wondering why we didn't do it that way.
I think that we're trying to find, the department's trying to find the best way to deal with the issues, the concerns that the commission has with respect to advertising in teams. And so with this regulation that we worked on drafting, and which, you know, of course, we need input from the commission, and we're trying to find the best way and the easiest way to deal with this issue of teams. And that's why in K, we included the word teams. So I think this is probably going to be the fastest and easiest way to deal with it, rather than, you know, changing statute or trying to change statute to include teams, in which I think that's what New York probably has it in their statutes, and we don't have it in our statute.
Peter Gray here, just a quick comment. It feels to me, it seems to me like the whole purpose of the team is really for someone other than the broker to act like a broker. So I really don't understand the purpose of a team. I really don't understand, instead of having a team, why whoever the team leader is, this just doesn't become the broker. I think that solves it.
I think there was some good. You had a chance to look at some of the others. Okay.
You're breaking up a little bit.
Can you hear me now?
Yes.
Okay. If you looked at, I went through a lot of the states on it. I know one of the ones I had mentioned last time around was Rhode Island. I felt Rhode Island touched base on a lot of things that we're looking for, but I think, you know, we're not going to be voting on this today or anything, but this is a chance for everyone that should be reviewing and looking exactly what other states are doing. There are, I believe, 28 or 28 states who now have either regulations or pertaining to teams. So these are things that we've got to review and look at and come up with something.
So you think we're stuck with it because this is really what's happening in the world?
I'm not sure we can modify it with regulations. What you're trying to get at, Peter?
Yeah. Yep.
Paulette, do you have any notes on that?
I think because the issue surrounding teams is about the advertising and misrepresentation, that's why we're trying to capture it here in the regulation having to do with advertising. And so, you know, we're looking forward to your, you know, the commission's input on some of the language that we have proposed. But I think, you know, the way I'm looking at it is, rather than creating something called teams in statute, because we have regulations in place already that has to do with advertising, to me it makes sense to try to capture that in this regulation that we have already. But again, you know, we're looking forward to the commission's input on what we have for language. And, you know, for section K, I'm sure there's like many more abbreviations and terms that we can come up with to sort of bolster that section as to what terms are prohibited. And if there's something more than the word teams, I know that Amy or somebody mentioned group, they've seen group, then, you know, let's try and, you know, bolster that up a bit.
We're trying, Peter, to work around existing right now.
Yeah, that makes a lot more sense also.
Yeah, to expedite this issue. Anybody want to talk about it and add? Well, I think we're probably going to wait till Julianne is back, and hopefully she's getting better. So I'd like you till our next meeting is to go over all what you've got, download it all, look at it, and add or discuss what your feelings are about teams, what we should be looking for.
And can I recommend, Ben, that if you have language that you want us to consider, that, because Julianne did send you an email, that perhaps you can send her a response to her email with some additional language. If you feel like you're not prepared to do that until you meet again or have a larger discussion, that's fine. But that's something that I would suggest.
If you, just to keep it simple, if you email it to me and then I'll look at it and forward it to Julianne or Paulette, so we can kind of keep it organized. Also, on that subject, make sure that Terry Jo is aware of the fact that you are coming to the meeting. Sometimes we assume we're getting things back and forth, but we need to know who is coming to the meetings. So make sure we have a quorum. All right. Okay, next. Mandatory courses, 2020 to 2022. All right, the education committee has come up with a course. Lucy, would you like to talk about this? You're muted.
Hear me?
Yes, we can hear you now.
Okay. Yeah, yeah. The committee, I think, each contributed sections and came up with an excellent course. It seems to meet the criteria that we were, trying to cover those items that there were some issues with. And I do have it available if anyone had specific questions about certain sections. Does anyone actually want to look at it?
I think we, I don't know if anybody downloaded. I did download the whole course itself. Did anyone do it also? Or look
I
through?
did. Yeah.
Okay. Peter, did you have any questions about it? I mean, just going through the course.
I thought it was very straightforward. It didn't look terribly different than the last go around that I saw. Were there major differences?
We tried to flip the script. Instead of just stating fair housing laws, we gave a lot of, fact patterns and real life scenarios, asked a lot more questions and had some discussion. So it was more in the approach that we took that was changed, but a lot of those fair housing issues still need to be addressed.
But the content was similar.
True.
Good, yeah.
Any questions on that? Okay, this is Connecticut Realtor Mandatory course, which we got a copy from Cindy. Cindy's here. Would you like to discuss that, Cindy?
Did you want, Ben, I can speak to that if you want. You all got the course content for the course on racial bias?
Yes.
Pardon me. So just to, a quick overview again, I think the intent of this was that we realize that this is a conversation that's more or less been in the shadows for a long time. There are a lot of things we weren't even aware of that was happening, things that were happening to our members out in the field. And the intention of this is to bring it out in the open with some understanding on what racial bias really is, microaggressions, and to give agents and our members the tools to help to prevent this when they recognize it. So the course includes a history of discrimination within our own organization, within the Realtor organizations, restrictive covenants that were in place here in Connecticut that created a lot of or prevented intergenerational wealth among communities of color. And then for those who think this is, and I've had very interesting conversations with members who really think, well, that happened 50 years ago, that doesn't apply to us anymore. So for those who think it doesn't apply to us anymore, we did include, of course, the Long Island study that was done by Newsday, and then the study that was done in the Boston area on discrimination in rental situations. Plus, we added in experiences that our own members have had. Some of the videos are using actors, but these are actual experiences that our own members have had here in Connecticut where they've experienced discrimination or bias. So we're hoping that this will change the way everyone looks at it. We're hoping that, I think the way the course is presented is going to be very important so that people feel comfortable having open discussions about this and won't come into this with a defensive attitude. So that is basically the content of the course. And if you have any questions, Cindy was the one who was deep in the weeds on this, working with Black scholars and our members on the task force to come up with the content so she can address any specific questions.
I had a question about the instructors for this class. How are they, is it any school can teach this class? I'm assuming because it's a required, it will potentially be a required class. And then how are we, as you said, Joanne, how are we ensuring that the instructor that's teaching the class understands this and teaches it in an appropriate way?
I'm going to let Cindy address that.
Yeah, Amy, that's one of the reasons a great deal of this course is video. So it removes there, and where I put, for example, the history, it's like read the slide, read the slide, read the slide, play the video. We agree with you. The instructor is going to make a huge difference, and we actually think that we need to write an opening script, which we can do today, that they read to the class at the start, just saying, everyone, just, we need to set the tone right from the beginning. But we think that it's so heavily scripted that it's hard to go off course, but we're of course very concerned about what could happen in a class. But we think the information is so crucial at this point in time that, it just needs to move forward. But we could certainly do a train the trainer course. We've tried to be really strict with the instructions and really narrow with where people could start to interject their own opinion or comments or something that's off track from what they need to be teaching. So, that's why it's so heavily
Cindy
video.
and I, we talked about this last night at length, that we do think there has to be some sort of a preamble, something that sets the tone the minute the students come in the door and sit down, because if the wrong tone is set from the beginning, then it's gonna shut some people down.
Yeah, and the other thing you may want to have
to comment as an
audits
instructor.
and classes. Like I would be happy to sit in, particularly when classes when they just start teaching it, to make sure that, instructors are teaching it in an appropriate way and things just don't go off the rails. Because based on message groups that I'm in on Facebook, I can see things very easily going off the rails, because not like, as you said, people don't think these are current problems, even though you're going to give them examples from 2018 and 2019.
You're absolutely right, Amy. That's our concern as well. Yeah.
And we could require that they take the course before they teach the course, which is one of the things we do with anything that we license. That would be up to you to set that requirement. But if they aren't clear on what they're supposed to be teaching, then they could define it.
Okay.
But if I can make a comment as an instructor, we did require train the trainer 2 cycles ago for fair housing, and I thought it worked very well. But I think that's one of the things with schools. It's up to each school to make sure that you have qualified instructors that are researching the information that is in the course, so that they are completely knowledgeable and they're not just regurgitating, reading off of a slide, because people don't learn that way. There needs to be interaction, there needs to be conversation. So I personally think it's a great idea to have instructors take the course from a knowledgeable person, like we did with the fair housing train the trainer, because this is so important. But I do think that it's important that the instructor be able to have a dialogue and, negotiate that dialogue with folks, because you want people talking in a class, you want people engaged. Otherwise the information just goes over their head, because all they're doing is pretending they're listening, but they're really not. So.
Yeah, and Kelly, I don't know if you've seen the class, but it is very interactive at parts.
Awesome.
We're after different video segments. It's like, now think about where this may have happened to you. Or for example, a lot of times, you know, people are asked to discriminate in listings. You know, what do you say? Or, and you know, because you're in real estate, they'll demand to know what schools, like, why aren't you just telling me about crime? Like, you know what the crime situation, why don't you just tell me? You know, that's something every day where we need to teach our members, this is how to correctly answer the question. But there are places in the instructor's notes where it says, this is a discussion to have right here. You know, this is where they need to write the script. This is where they need to say what's different. Even when we did the bias test, people didn't understand why finding out that 20 out of 20 showed their entire universe was white, they still weren't connecting why that had anything to do with this course. You know, so even that part, we just really strongly feel we need to say to the instructors, this is what you need to say to them when, you know, 80, 90% of the class has 20 out of 20 for what their universe looks like.
Awesome.
So it is built in there.
Awesome.
Can I just add that in an interactive forum, which is what you've created through the online classes, there's a reality here that no matter what the topic is, you're going to have individuals, and this is a good thing, you know, who will have questions that an instructor, and especially when you have a subject such as racialized, you know, the bias and such, that if a person's not coming from a place of sensitivity or a place of experience, sometimes it's hard to respond in that situation. So I think there might need to be, when you do, and I think it's a really great idea for the course providers to take the course, but to also have, you know, those who are teaching it sort of, you know, engage them in difficult questions that could come up to sort of see how they would respond to those questions. Of course, you know, there's a universe of questions that you might not be able to address everything, but they should be prepared to have an open dialogue with the students about these hard questions. And whether, you know, sometimes, you know, if you say, just go back to the script, it will leave people frustrated. And they're not learning if it's like, go back to the script, because the instructor might not know how to address that particular question or concern. So that's something I think, you know, I would suggest to keep in mind when you're teaching the instructors is, you know, throw out some questions. Maybe you might need in that audience, you know, people, you know, individuals of color who could, you know, bring up some questions that perhaps someone might not have thought about if they're not a person experiencing this type of racial bias in real estate.
Well, and that's definitely part of the difficulty. We know from our own, and I don't know if the department ever looks at every occupation to see what the demographics of, you know, who are the doctors, who are the lawyers, who are the real estate agents, who are the appraisers, but 94% of our class attendees are very likely to be white. You know, so it is, which is one of the reasons we need to do this, you know, so I agree with you. I just don't know if we have the volume who will be participating, because our industry right now, and that's another whole issue we're working on, our industry is not attracting a diverse population to enter it. But I agree with you. And we need, the other thing, and this is what's going to be hard to evaluate from the instructor, they need to make the students feel safe to ask questions. And the student, and they need to be prepared. Students in the class need to be prepared for how much people really don't know about this topic. I mean, they really don't understand that some of our Black agents get followed around like they're going to rob a house. You know, they don't understand that's part of what's happening right now. And it's terrible, but I agree with you. The whole sensitivity part, I think people are going to be shocked when they hear the type of stuff that comes up and how just incredibly terrible it is. And that's why we're just so thrilled that you all are open to having this be a mandatory course, because we think we'd get 30 people there if it wasn't, because no one thinks they need the class. It's not me,
I was on a phone conversation last night with a member who called me specifically about this whole thing. And she said, I'm really She's a white member, and she said, I'm insulted. I'm insulted that I have to take a class. I've never been racist in my whole life. And again, it's the exact, it's that mindset that, you know, I said, you have to understand this class isn't an accusatory situation. We're not accusing anyone of being racist. It's simply to educate and open up your eyes to things you didn't even know were going on. And she said, I've never had one of my sellers, you know, I've never heard that one of my sellers turned away a realtor of color, didn't let him come in the front door. I said, because that realtor of color probably wasn't not comfortable picking up the phone and telling you what just went on. You know, I said, those are the kinds of things that we're trying to address. So, it's a necessary, I feel so passionately that this is so long overdue. And as Cindy said, we are ecstatic that you're all so open to this and behind us on this.
Lucy, do you have any comments on here? How can we add this in? How can we work this?
I did have one question. Is this something that needs to be done recurrently with each cycle, or is this a one-time kind of a thing?
Both mandatory courses would be for the 2022 cycle. So whether or not they're recurring, I'm not sure. I guess depending on how things go. Since most of the licensees don't take the course until, you know, the end of the cycle next May, you know, I think things will hopefully improve by then because everything is being brought to the forefront. But I think we just have to wait and see how that goes.
I think this is a course too that will evolve over time, you know, as it's rolled out and we learn more from the reaction to it, and maybe what needs to be put in or taken out, we'll be looking at that.
Also, I might add, it's mandatory for this cycle, but then it will stay on as a regular CE course that people can take in the future.
That can change.
Mm-hmm.
Okay. Currently, right now, we've got we've been to the 2 mandatory courses. A little confusing. Would this be added to the racial bias for real estate course, mandatory, additionally?
It's 2 separate courses, each 3 credits.
Okay.
So we'll have 2 mandatory courses, similar to what we did last cycle, except that was sort of one course that was just split in 2. These are 2 separate mandatory courses.
Okay, do we want to, any other questions regarding these courses from anyone? The next topic is Connecticut Real Estate Mandatory CE courses for 2020. We've talked about that. We want to vote on the CE courses for this cycle. Are we ready to vote on that? Any other questions?
Excuse me for interrupting. This is Fran Kuttner with the CE Shop. I don't know if the timing is right, but I wanted to bring to the floor the discussion about these courses only being able to be provided by in-person or live virtual. Is now the time to discuss it, or did I jump in at the wrong time?
We can discuss it now.
So
thanks, Brandon. I can kind of head in there. Thank you for that. So my name is Mike Matouche. I'm the education director for the CE Shop, and we've offered the Connecticut core fully online for the past 2 cycles. And we did notice in the February 5th meeting that looks like when the decision was made. We're just hoping to get some background on that decision process, and if there's something in particular that needs to be addressed. because we've served a lot of licensees who are already asking for availability of these courses once they're complete. So, is it possible to get some background on that decision that was made?
You want, this is Jill Conklin with, I work at DCP, I'm the real estate examiner. As you just heard, Mike, these courses were written with the intent of being served as a live classroom, if we go back to that, or live virtual. They weren't written to be, excuse me, they weren't written to be just plugged in and gone through individually, hitting slides or just listening to videos. It needs an instructor, and that's why they're going to have a train the trainer. The instructors are going to have to take the course. There's a lot more detail that's buried in, because you could just flip through that slide and get through it very quickly. It's not going to be 3 hours. The discussion is what takes up the time. So yes, it's going to be available either live in person or via Zoom or WebEx or whatever you want to do. There's going to be a live trainer in each class.
So understanding the need, and the previous conversation did help kind of set the picture for that, but understanding the need to ensure that students aren't able just to passively learn, click, read, click next, take an exam and be done. Online's come a long ways since those days, and there are a lot of interactive opportunities, plenty of knowledge retention checks. There's opportunity to engage instructors with recorded materials. There's even discussion forums that can be held within online courses. So I believe strongly that there is still the ability to offer a course asynchronously, fully online, that includes the interactive components that are necessary to ensure knowledge retention and to ensure a non-passive environment where students do have to actually engage and interact with the content.
Well, this course wasn't written that way, where they're going to engage on the content with clicking something. It's not, it's meant to be taught in person or live virtual.
I think part of the issue that is driving this is, you know, while you may feel that you can be interactive in other ways and have discussion forums and things like that, there are a large number of examples that have come through where people are taking online courses and they can get through a course in 15 minutes and still get their 3-hour credit. And there is little learning or engagement in those. And, you know, this seems to be happening more often than not, I think, and that's a large part of the problem. And, you know, these are topics that, you know, you can still take 6 hours of your continuing ed without a virtual or without a live virtual class or in person. But for 6 hours, we want you paying attention. We want you engaging with fellow classmates and an instructor in an active led session to maybe, I don't know, emphasize your learning a little bit more. And that's why we're making these 2 classes mandatory, because they're really important topics.
So with regard to students being able to get through courses that quickly without actually demonstrating knowledge of the materials, there's a lot of tools that can be used and resources that can be used to prevent that. I know Connecticut has been somewhat active with Arello, and there's distance education certification program that requires a certain level of interactivity. And then in addition to that, you know, commissions can require whatever they need to do in terms of timing, interactivity. I will say that, you know, we see that too in other online providers. And quite frankly, it's hard to compete with dishonest providers who offer a cheap and easy way for students to get through. But there's also quality product online. And in the case of these last 2 courses for the last cycle, you know, just we had over 5,000 students complete each one, and the average timing on each one was 177 minutes on average to get through. The other one was 180. So we certainly don't see students completing quality courses in that amount of time. And the reason for that is because they do have to absorb the content. They have to demonstrate an understanding of the knowledge. So, I get the concern. We see it as well. But I want to just make sure everybody knows that there is ways that those concerns can be reduced and alleviated through technology and through requirements.
Actually, I personally used the CE shop. I was a customer. I did want to get through it as fast as possible. I found that I had to engage. I found that I had to learn the material. I found that it took me a fair amount of time. And I found that I took the tests and I was able to demonstrate that I learned the materials. I was impressed. I thought it did a very good job. And what I liked is that it allowed access where I may not have otherwise had easy access. But the online teaching, which we're also allowing, is also, my concern is about access. So I believe that at least is covered, at least, to a large extent.
And just to add on to this, it's Fran again with the CE shop. In reading the rules, and correct me if I'm wrong, there is a rule that says a course can't be disapproved, or a school can't be disapproved to offer a course solely because the school is an online school, and then a course can't be disapproved solely because it's offered online. So when you're speaking about having created a course that is only or better served, I'm paraphrasing, but to be in person or live virtual, that seems to almost go against the rule, because it puts out those online schools, because we're being told that the course wasn't drafted to be offered that way. And I don't see, and again, I don't know your rules like you do, but is there a rule saying that that a course can be drafted only to be offered in a classroom?
This is Paula from DCP Legal Division. So live virtual, it is an online forum format. So the statute is not disallowing online courses. So I think that the difference here, whether there is a difference, is the type of online course that's being offered for CE shop, which would be, I guess there's not a live instructor. Is that what I'm to understand? Because I don't understand it completely, but a course would not be denied because it's online, because this type of learning is online.
Right, but we're asynchronous online, and do your rules distinguish that it can only be virtual online versus any other, so synchronous online versus asynchronous? Because I just didn't see the language, and so I want to understand.
It doesn't, and I don't think that it needs to. I mean, the discretion really is up to the commission in terms of when they when these types of courses are created, as to which course providers they would approve for these mandatory courses. So my suggestion would be, because I'm hearing that from CE shop, as well as Peter Gray's experience, he's on the commission, that some of the issues that the commission has with respect to these mandatory courses that need is that they want to ensure that there's engagement with the students. They want to ensure that this information that they're getting about the racialized bias is actually being learned. So perhaps maybe you can explain or give examples to the commission as to how you perceive that you would overcome these concerns that the commission has with respect to these mandatory courses. That might be helpful in them understanding, the commission understanding how you propose to alleviate these concerns.
Could certainly take a while to go through all the examples that we use to distribute content. But, I mean, one of the things that was mentioned was concern about consistency in delivery and the integrity of the course. And that's an area where a fully online asynchronous course can check all those boxes, obviously. I mean, the course is available to the entire commission, to anybody who wants to review it, and it's consistent. So everybody hears the the exact same message in terms of the interactive component and ensuring that people aren't just in one ear out the other. That's where the additional activities and exercises come in. And you've got everything from, you know, branching scenarios where you have to go down the right path. You're given a scenario, you have to go through the right path or you're never going to complete the course. You have to get to the right end result. And a lot of times where that's valuable is in the case of, you know, in case studies and real cases where you need to walk through students that. And it's not a two-way conversation as much as an instructor physically telling the student, nope, that you got that wrong and here's why. But there is verbiage built into that process that explains from an instructor or an expert point of view why the scenario they just went down is not correct and steers them back into the right path. So there's a lot of things like that. Obviously, you've got video messaging. It sounds like the course on the racial bias is fairly heavy on video. And I mean, there isn't a better forum, to be honest, for video content, as long as you're following it up with something that actually makes sure people weren't just tuning it out, that follows up with activities that go back and confirm that they not only that they not only heard the content, that they understand what's you know what they're supposed to be taking away from it. It's objective based. You know, you start with an objective just like any course, and those objectives have to be met. Have to prove that those objectives are met. And I guess one thing, and I know we're running close on time, and sorry to consume so much of your time on this topic. But I guess I would just ask that we be afforded the opportunity to present a course for commission consideration. And if it can meet all of those requirements, that it be considered for approval rather than just kind of disallowing it out of the gate.
I think the time, though, to review all these courses is going to be difficult. This is a cycle that's it's kind of late at this point in time to do this. Matter of fact, I want, before I forget, we have to vote on the approval of these the CE courses. I thought you were going to add something else into the course. I think it's something we can review, but I don't think this is the time to do so. I think we're late.
I'm sorry, excuse me. Did you say, I didn't hear your last thing. Did you say it's late?
Yes.
Well, again, Fran from the CE shop, sorry. So that statement kind of concerns me because we've been going back and forth with the commission for months, and we've been being put off, and told to wait because the course wasn't written, and again, I'm paraphrasing, I don't want to misquote anyone or anything, but we've been delayed, and now when the course finally comes up for discussion, we're being told it's too late. So that makes me so uncomfortable. I don't understand.
And just for clarification, she doesn't mean the commission, she means the department.
Okay.
Two different separate things.
Me. Yes, thank you for that.
I was not aware of that. I'm thinking, we're not aware of this. All right. Thank you. All right, anything else? All right, with that said, let's go back to the approval of the course. See for 2022 cycle. Make a motion for approval.
We move that we approve the course as written.
Second, anybody second?
Which course are we talking about?
We're talking about
the one that was presented by Ms. Mouchard. Sorry, I butchered her name.
Okay.
It's a CT.
Second.
I'm sorry, go ahead. Second.
Can I just seconded it?
Discussion? All in favor?
Aye.
Aye.
Opposed? Pass. Okay, thank you. All right. Okay, we have old business with the Mr. Trojanowski? Is Mr. Trojanowski here today?
Wait, Ben, are we also making the CTR course mandatory as well?
I think that requires a separate vote.
That was for both.
That's for both, yes.
Okay, thank you. All right.
I apologize. Mr. Trojanowski here today?
Yes, I am.
This is regarding.
Hello?
Are you here?
Yeah, can you hear me?
Yes, okay. In June, you had come in front of us regarding your license being reinstated. Your existing, your license was revoked.
Can I clarify? Just let's not use the word reinstatement because it's not a reinstatement.
Okay.
It's a new license application review because we don't have a mechanism for reinstatement for revoked licenses under our statute. I just want to make that clarification. Thank you.
So this would be, not as old, this is new. Okay. Got it.
All right, so I'm sorry. So I was not here for that June meeting or whenever this last occurred. So should I participate in this or not?
Yes.
Okay, thank you.
This is, okay.
For on Amy's benefit, maybe, and maybe for all of our benefits, we should go through a quick review of.
I think I want, yeah, let's review it exactly what transpired, just to refresh us. Actually, Kelly, would you mind discussing this?
Yeah, Kelly can't discuss it because she's not,
Okay.
love Kelly. But yeah, it has to be the department.
Okay. Jill, I know we're kind of catching you in between here, but what can you tell us?
I personally, I wasn't involved with that case, and I don't, I know there was monies that were misappropriated, and
Why don't I do it? Why don't I do it?
Okay, go ahead.
Okay.
Please.
All right. So back in 2019, the commission heard an enforcement case that was brought by the department against Mr. Trojanowski, and in that decision, and Mr. Trojanowski was not present at the hearing. And so the case went forward. And in that case, the department had determined that Mr. Trojanowski was in violation of our real estate licensing laws. I don't have the final decision before me, so I can't go into what the details were. But I think what's important is that based on the commission's finding that he was in violation of our real estate licensing laws, the commission then had, in their final decision order, had issued a civil penalty. I think it was 1,000 or 2,000. I can't remember what the total was. And then so Mr. Trojanowski had a period of time in which to comply with the final decision order. He had requested reconsideration of his decision, which the department had denied. And then following the denial of the reconsideration, Mr. Trojanowski did not pay the civil penalty under the final decision order. And so his license was revoked. So fast forward to 2020, where Mr. Trojanowski did come before the commission to request reinstatement of his license. And at that meeting, he had not paid the civil penalty under that final decision order. And so the commission had decided they cannot hear his request for reinstatement because he was not in compliance with the final decision order. Subsequent to that, he did pay the civil penalty. And so now, because, as I had stated earlier, our statutes, unlike the occupational trade statute, where we do have a reinstatement provision, for the real estate laws, we do not have a reinstatement provision. So he had to apply for a new license which is why we're here today, where the commission now must decide whether they will allow Mr. Trojanowski to obtain his broker's license. And we're looking at, so under our statute for license qualifications, it's 20-314. And under 20-314, there's several elements. There's one where typically where there's a new applicant who is going from salesperson to now broker. There are certain considerations. So 1-2 years being a salesperson, and then the completion of the 60 hours of the PMP, and then the 15 classroom hours for the, and I don't know if it's probably still 15 for the broker classroom hours, and then there's a B, if not considering that, then equivalent experience or education as determined by the commission. So these are ways that the commission can look at this new application for a broker's license.
So is he looking to sit to take the exam? Or is he sitting to look for just reinstatement? Or gosh, not reinstatement, excuse me, new license.
I believe he's looking for a new broker license.
Broker license.
And I don't know if it's entity or individual broker. I didn't understand. I don't know. What did the application say? Because I think you all have a copy of the application.
The application is in his personal name.
Okay. All right.
And he's looking to waive all that. He's looking to waive the 60 hours because back when he got his license, he would have only probably had the 30 hours. And he wouldn't have taken the new broker course, the 15-hour course.
The application, I had a question about the application. In where it says number 3, have you ever had a real estate license refused, suspended, revoked? He's checked yes. Then it says, if yes, attach a statement providing details regarding the type of action taken. And it says not applicable. Why is that an A?
Can anybody answer that? Hello?
Yeah, I may be able to answer the question. Which question are you? It's a license. It's not an LLC. And I did take the broker licensing exam way back when. I got my broker's license back in 1987, I believe it is, or 86. So whatever was the prevailing requirement at the time. I think initially when I got the real estate license, I got the it was the 30-hour course, but then I had to take the broker's test and the broker's licensing hours and the appraisal course as well in order to establish the broker's test or to gain the broker's license.
Which we no longer have. You don't longer have that license.
Well, no, it was, you guys revoked it. The broker's license. And so this is to reestablish a broker's license based upon what I had before, which is a broker's license. And since I guess the statute provides to not reinstate, but apply anew, then that's where I'm at.
And you're looking for us to waiver the criterias for that.
Well, yeah, and I think that the chronology that was outlined there, yes, I am. The short answer is yes. I have, to just give you the background, I originally got my real estate sales license in 1979. 74. Okay. And but then I moved away to California from 78 to 84. So my license had expired at that point. So then I took all the courses anew back in 84 and got my salesperson's license. At that time, there was a 2-year wait. So then I took the required courses to get the broker's license in 86 or 87.
Which was 30 hours back then, right?
Excuse me?
30 hours back then.
Yeah, whatever that was at that time, I don't recall.
Yeah, that would have been 30 hours back then in the 87, 84.
And for clarification for the commission, it's you don't. There are two things. There's one, it's the waiver, but also you could instead of the waiver, you could consider under 20-3114 section DB whether he has equivalent experience or education in order to get the broker license. So it doesn't necessarily have to be waiver. It could be, equivalent experience, but that would be up to you to determine through questions asked to Mr. Trojanowski in order to make that determination.
Under the circumstances, past history here, having a license revoked, we feel comfortable waiver in these criteria that PSI is going to require. Testing.
I'm sorry, I didn't hear what you said. You were kind of breaking up.
Because of the situation that Mr. Trojanowski has been by having his previous license revoked, I would have a problem with that. I think he has to meet the PSI requirements if we approve this.
Well, that's fine. I'll abide by whatever decision is to reestablish the license, if that means taking the test or not. Okay. However, I have been, practicing, continuously since 1985, and I wanted to address the issue regarding the chronology here because, in fact, there wasn't any issue regarding any funds that were taken away. So, initially when there was a complaint made, I submitted information most recently that the complainant got all the funds that they were required at that time, which was going back to February of 16. The initial meeting that the commission had to review my situation was in November of 18. And I had gotten a letter from you all in December of 18 about the revocation. And I submitted a letter at that time because I had new information, which was in fact the information about the complainant's issue. And I could prove at that time that the complainant got their funds and that there was no violation. I was rejected at that time. And I requested again in February of 19 to the commission to review, and they didn't. They dismissed it and said that it wasn't new information, and so consequently, here I am. Okay.
Well, could you reiterate for us again what his violations were? Paula, you're on mute.
Go ahead. You're mute.
Mute, unmute.
There you go.
I just want to open up the final decision. Give me a sec, please.
Did you hear Linda's question?
Yep.
Okay.
So in the final decision order, the commission had found that so it was a $2,000 civil penalty, revocation of his license for failing within a reasonable time to account for or remit any monies coming into the respondent's possession which belongs to another, and for conduct and action which constitutes dishonest, fraudulent, or improper dealings, or violation of any provision of Chapter 392. So that's what the commission had found. And yes, it was 2018. Time has flown. I don't know why I thought it was 2019. And so I don't know if you want me to get into the facts, but if this is helpful to the commission, let me just email this to Terry Jo, and if she can put it up on the screen. Would that be helpful?
My question is, I don't see anything barring Mr. Trojanowski from applying for a new license. I saw the $2,000 was paid. I see the $200 was paid. I don't, am I missing something? What are we considering? What are we potentially voting on today?
Whether or not to allow him to sit for the exam.
Whether or not to allow, okay, so then we have to discuss it and decide whether we want to allow that. So that's the issue. Is this whether we are allowing Mr. Trojanowski to sit for the exam without additional education, or is this with the additional education?
First of all, he has to meet the current requirements. I mean, I can't see. Not only that, the question would be does he need additional education based on his past?
I see.
This is my feelings. Anybody else wants to discuss this?
13.
I cannot hear. I don't know about, I can't hear.
Can't hear.
Excuse me, Mr. Trojanowski, can you hear us?
Yes, I'm sorry.
Yes, thank you so much. We were having a hard time hearing you.
What was the question? I couldn't hear you either. It was a little, the connection is bad where I am.
Sure, and if you could just keep the phone a little bit closer to your mouth so that the board members can hear you. Thank you.
Okay.
All right, the question, Peter? You're muted, Pete. Peter, you had the question?
I'm sorry, you're asking me to repeat my question? What I was asking is what we're really deciding on today. And I think the answer that I heard from you was that the decision is whether to allow Mr. Trojanowski to sit for the exam or not. And at least to my mind, he's, fulfilled his part of the bargain.
Anybody else? Linda, you had some. Linda, can you hear me? Yeah.
I can, Ben.
Go ahead. You had some question about this?
No, just a question I asked Paulette. She already answered it.
Okay, she got your answer. Okay.
Well, I guess my concern again, of course, is that how do we know that, how are we going to watch to make sure that this doesn't happen again? And I think I've been through this before with the department, and I guess I'm told there's not very many ways to do it. I'm wondering if there's some way we could look and see, particularly with the accounting, to make sure that not only does he understand how to account, but that he actually does it.
So with a new application, I don't think that you can have a different or special requirement for the applicant. So you have to look at it like a brand new application. And some of the things that you can consider under the law is, and I'm reading straight from the statute, the commission may require such information with regard to an applicant as the commission deems desirable with due regard to the paramount interests of the public as to the honesty, truthfulness, integrity, and competency of the applicant. And that's in addition to the education and experience. So we want to make sure that in reviewing Mr. Trojanowski's application, that there isn't any additional requirements than any other new applicant.
Hate to make you do this. Could you repeat that one more time so
Sure.
we can hear this?
Sure. So the commission may require such information with regard to an applicant as the commission deems desirable with due regard to the paramount interests of the public as to the honesty, truthfulness, integrity, and competency of the applicant. And that's in addition to the education and experience. So that's your universe in looking at any new applicant. So you can't have a requirement where you're going to include, we're gonna, ask this new applicant to provide us with information about their business or period of time. Typically, those types of things occur when you have a hearing and a decision. So each applicant has to be treated the same way as the statute requires.
In relation to that, I feel that we've been schooled in his character and as it pertains to the honesty, integrity, et cetera, that you just mentioned, Paulette. And asking you to repeat what his violations were, I think that we've heard that once again. And I agree with Ted, by the way, as far as being able to track the situation, and you answered that satisfactorily too, Paulette. I appreciate it.
If I may jump in here, the commission did find me in violation, but I must say that it's without all the information because I was not able to present my case in November of 18. And I missed that meeting, and as I said before, I apologize for that. But that should not cast aspersions on my honesty and integrity, because the commission made their decision based upon the information they had at the time. And I submitted the information, copies of checks that was given to the owners at the time that I stopped working for them, which was in March of 16. Okay. So, in fact, there really wasn't any violation. It's just that there wasn't enough information at the time. And I did ask the commission to rehear. So, to say that I'm less than honest about what went on isn't factual. Again, the commission made.
Excuse me, but you had the opportunity to come before us in November. You didn't?
I didn't. You're right, and I apologize for that. I didn't, but because I didn't come before you, it does not mean that I'm also a liar and committed malfeasance.
May I suggest that if the commission has any questions for Mr. Trojanowski, that would help the commission to understand or feel more comfortable about going forward. This is an opportunity to ask him questions with respect to honesty, truthfulness, integrity, that kind of thing. Giving him an opportunity to make a statement or whatever it is might be helpful to the commission.
Before we do that, Paulette, question on the application. Is his past conduct relevant to this application? Or has he been fined and that's the past?
been fined. He's paid the fine, and that's true and everything. But, you know, it's at the discretion of the commission to decide whether or not, and this is true for any applicant, and typically you probably don't have an applicant coming before you. You usually just have, you know, the application itself and not the individual to ask questions. So this is a different scenario, but I think you can still ask questions relevant to truthfulness, integrity, and such to the applicant.
He's also applying, I think we gotta keep in mind, he's also applying for a broker's license. Am I correct? He's not applying for a salesman's license. He's applying for a broker's license. Now, I think in the past, similar situations has occurred on it, and I think we've had people apply for a salesman's license, but he's jumping right into the broker's license. Broker's license showing, you know, and the responsibility that goes along with a broker's license.
To me, I have one question, which to me, what we're talking about is good moral character. And to me, a big part of the definition of that is I'd like, and I don't want to ask this question until Paulette says it's okay to ask, but to me the question is, has, you know, an applicant been convicted of a crime? Is that an allowable question, and is that already on the application, the answer to this?
Yeah, this is not a matter about a criminal conviction, so yeah, that would not be relevant.
Okay.
Well, that's going back again. I think my question about the application wasn't answered before. I asked about paragraph 3, where it asked about if he'd ever been suspended, and he did say yes. But then when he was asked to attach a statement providing information about that, he said not applicable. And I don't know whether that was not applicable because he knows that we know about it, or whether, I mean, I don't quite know why the NA is after that.
Again, you want to explain that again, Mr. Janowski?
I can answer that very simply. Yes, the commission is aware of it, and so I'm going for the people that in fact made the decision for the revocation. So I mean, you know, I certainly would, you know, provide information if you know, if this was a new situation or something that you weren't aware of. But again, you know, the application here, you know, you all are looking at this as a, you know, did I fill out the application correctly? And I think it goes to the point of my honesty. You know, as I said, I got my first license in 1974. Okay, so my 17 years old, I sold my first house when I was 18. Okay, 1976. Okay, I worked as a property manager in Los Angeles for 6 years. Okay, then I came back here and went through the whole process again of salesmanship, broker licenses, and I've been operating, you know, for more than 30 years. Okay, so if you need to consider, you know, a history. Okay, there is a history there, and you guys working in the state of Connecticut, you guys have all access to all the information about any previous concerns that there were before. Okay, and I maintain that the commission made the decision, a violation based upon the information they had. Okay, because I did miss the meeting, I would have provided the information at the time. And I provided the information where the owner was correctly, you know, given their funds at the time that I stopped working for them. So there really is no violation except that I didn't show up for the meeting, and the commission was forced to make a decision, again, based upon what they were dealing with the information they had at the time. So there isn't any malfeasance here. So there isn't any aspersions or derogatory information regarding any, you know, misuse of funds. or mishandling of funds. What it is that I did not make the meeting. And you all made the decision based upon what you had at the time, which is, of course, understandable. Okay? And I did attempt to rectify that by providing the additional and new information, which in the letter sent to me in December of 18 about the revocation, is that there was a period of time in which I was able to provide additional information that would have been cogent to the matter at hand here. And I was not able to submit it. And this could have been resolved. If I had a second meeting, I could have provided this information and we could have resolved it at that point, you know. Again, I'm sorry that I didn't make the meeting, okay? As I mentioned in a previous meeting with you, a face-to-face meeting back in February, I was going through a depression at the time, and this added to a lot of what was going on. So, you know, I apologize immensely and over again for not making that meeting. But the fact is that there was no malfeasance, okay? There was no violation. So that and the 35-year plus history I have, I think, you know, is something that can be relied on. And again, you all have access to my whole history for the whole 35 years. Okay.
Paul, I got a question for you. Did we ever receive confirmation that he's I think it was about a deposit or something of that complaint? Do we ever get a copy? We got a copy of it, but do we know if the complaint got the money back? Did she get her money back?
The last communication I had with the attorney, which was a while ago, at that time, the response was no. But keep in mind also that with this complaint that we had, we were not seeking restitution. So just keep that in mind. We were not seeking restitution. But the last communication I had with the attorney, when I asked the question, the response was no at that time.
You say the attorney. Whose attorney?
The attorney for the complainants.
The last communication, when was that?
Oh, over a year ago.
You're saying that, go ahead.
I was going to say, I'll give you some background on the situation. The situation was brief. That the attorney represented an elderly woman, okay, who lived in Stratford and had two properties and a not so great section in Bridgeport on the east side, East Main Street. So he came in afterward because she had been in the hospital. I deposited the funds. There was a period of time where she had a handyman handing over the stuff. I had communication with the attorney up until November of 2016 because they had requested information about the leases that I had done at the time while I was involved, and it was only a 6-month period. Okay, I leased up 4 of the units. Okay, 2 of which were Section 8, which I don't know if you're familiar with that or not, but they're very detailed in terms of you know, requirements for pay taxes and inspections and lead and all those kinds of things. Okay, so there was a disconnect there. I made the deposits directly into the woman's account. I never handled her money in terms of into my own account. I just put it directly into her account. And the Section 8s also were direct deposits into her account. Okay, so there was a disconnect, and the attorney asked for information. Meanwhile, I was dealing with his paralegal, and I sent him all kinds of information. So the attorney made the complaint, and then, but I was still in communication with his paralegal for all the documentation regarding leases and so on. So I don't even know if he knows that he got the money. Okay, but what I had documented with you all is that in March of 2016, I provided a copy of her bank account with her name in People's Bank for in which I deposited, and I provided the deposit slip of the funds and a copy of her deposit slip, which is how I operated with any deposits. So the information you guys have there is a copy of her deposit slip with the funds going into the account and a deposit slip verifying when they went in there, which I think was about March 16th or so of 2016. So that's the background on how this all happened. I never heard from Tony.
I think you're saying deposit account. We need a confirmation though from her attorneys or confirmation from her. The fact is that money was returned in full. Did we ever get that?
Well, I don't know. I mean, I tendered all the funds that I had.
I'm sorry,
So, you know, when we had last met, you know, Paulette had mentioned that, because the question came up before, you know, was there ever a complaint or a suit filed against me? And the answer is no. The attorney never pursued me about anything. This complaint was thrown out there, and then I never heard from him again except his paralegal to provide lease information, copies of leases. And that was in November of 2016, I provided that information. So I was still continuing to cooperate with them. The woman, you know, is 96 years old, so I don't even know if she's still alive or not or what. But the attorney was handling it. He's the one that made the complaint.
And I believe that Mr. Trojanowski did provide a copy of a receipt from the last time the commission had met. Terry Jo, do you still have that? Were you around that time, Terry Jo? I don't even know if you're around that time.
No, unfortunately, that predates me, but I'm looking in his credentials right now to see if I have a copy of it.
Okay.
I recollect seeing that as well.
Yeah.
Okay, I mean, I think that's the important thing. I believe we've asked this before, and we never got any evidence. We've asked this question before.
And while we're waiting for that, I also had a question about I can't remember who's asking, but Paulette, the compliance, Mr. Trojanowski, during this situation, was he compliant? Was there evidence he was not compliant with the department?
Compliant how? What do you mean?
Responding timely?
Well, this is always my position when it comes to that part of the statute with respect to cooperating with an open investigation. I would never bring a case forward just based on that. I've always made that clear. Kelly knows that when she was working for the department. So my opinion, that would not be something that I would be laying my hat on in terms of you know, keeping a person from getting their license, because the reality is, in the end, the commission did make their decision and their finding that Mr. Trojanowski had violated the licensing laws, and he was issued the civil penalty, which he subsequently paid. So that's my position on that. That, you know, that's neither here nor there with me in terms of an enforcement case.
That was an administration hearing, am I correct?
Yeah, formal administrative hearing, yeah.
Don't get confused. This hearing never came in front of us, right?
It came before you.
It came for us?
Yes.
It came before you. You heard that case, yeah.
You just
We're the ones who issued the $2,000 penalty, which he has
Right.
to now pay.
Right. But remember, the case was not just about him not cooperating.
Right.
the main underlying issue had to do with the funds.
But as I recall, and this is only my recollection, he was not responsive to the department. The department had to continue to chase him. When the fine was pronounced, he neglected to pay the fine also.
I would have to disagree with that. I did not go to the meeting, okay? But there was never any definitive, and this is one of the things that I brought up in the February meeting when we actually met for face-to-face. There was never any definitive question as to whether, or a requirement as to paying the fine. Now, before I go before the commission or afterward, I could find nowhere where it says, you have to pay the fine by such and such a date. So it's not, again, I didn't go to the meeting in November of 18, but I responded in December of 18 to the letter and the findings and tried to get to resolve this all through 19 as well. So to say that I was not responsive, I think mischaracterizes the situation, because I did respond, and I missed the meeting in November, and again, that I apologize immensely for. But really, this is what this is coming down to. It's coming down to missing the meeting. There was no, no negative, negativity, toward the commission itself, okay? I have been on these commissions myself. I'm a former Bridgeport board president and Realtor, commission, Realtor committee member for the National Association of Realtors as well as the Connecticut Association of Realtors. So I have a long history of working with the commission and involved both, in the state, local, and national level. So, I respect the commission and I respect, the work that they do. So it was not, a flippant thing to miss the meeting. Okay. But that's what this is coming down to, because I missed the meeting, the commission didn't get the full picture. And so consequently, they made the decision that they thought was correct at the time. Again, in December, I tried to correct that by December of 18. I tried to correct that by asking for an additional meeting, in which I would have provided the information that they needed. And that's why we're here now. My fault.
Also, I don't really understand. It's hard to believe that you wouldn't have picked up the phone or sent an email and asked, should I be paying the $2,000 fine now, or should I wait? Or, it sounded to me that if I'm not going to get my life, why pay it? I didn't like that feeling at all. I'm not sure what that's all about. Why did you check into it? You said you weren't quite sure. So find out if you weren't quite sure.
Well, again, nothing indicated to me that the fine was due at a specific time. So, the bottom line is that I intended to go to the meeting, and as I did in last February, and make the determination and try to present my case. Okay, so because I was denied the opportunity to ever present my case, as I requested in December of 2018. So, for me to start thinking, well, I should just pay the fine and not get further directions. As I mentioned, and you can check the minutes of the meeting from February, there was no indication when to pay the fine, and there was no clarification on what was involved. So, I mean, there's enough gray area there where I figured, let me go to the meeting and get a determination on what is required. Clear my name and make sure that, you know, I can get a definitive direction.
And Mr. Trojanowski is correct that in the final decision order, there is no time frame in which the civil penalty was due. That was missing from the decision. And we have had cases where an individual has come on the date of, let's say it was a meeting today, and paid the civil penalty that day. And then, you know, it would be, let's say the board would say, okay, if you pay the civil penalty today, by end of day, then we will reinstate your license once we get proof of payment. So the fact that he had come to that last meeting and had not paid the civil penalty by that time, I don't think that should be, you know, something against him, because we have had cases where individuals come the day of where they're requesting reinstatement, for example, and had an opportunity to pay the civil penalty that day. But we did not have that, the commission did not have that in their decision, a time frame in which the individual should pay the civil penalty. Mr. Trojanowski should pay the civil penalty. So I just want to make sure that we all understand that.
And also, I agree with what you said about this being an application for a broker. I think this is very different from a salesperson. I mean, I think a salesperson would be supervised. A broker is going to be supervising other brokers. So I think it's a big difference.
I agree with Ted and Ben.
I agree with Ted. So the question is, I guess, we're getting into, should we make a decision to let him sit for the salesman's license versus the broker's license? I mean, and there's also classes and courses. I mean, you're going to get re-educated a little bit.
If I may, I don't know that you can ask him to go back to a salesperson's license. He's already fulfilled that requirement for a salesperson's license, and the application is for a broker's license. I don't see where in the statute that the commission has that discretion to now say you can apply, you should be applying for a salesperson's license. I've not seen that. I mean, I need to look at it again, but I haven't seen that.
I think we would not be saying that. We would just be saying that, you know, that his broker's application would not be acceptable, but he can also apply for a salesperson's license. And if he read the tea leaves, he would see that he might be able to get that.
And what would, and you need to explain the basis here, because like what is,
because
what
the salesperson
concern
doesn't
that the
need to
commission
show-
has?
The concern is what we have is that what his past has been. A lack of training other agents, being responsible for other agents. This is what we're giving him permission to do by giving him a broker's license on it.
So it's based on, you're basing it on what? The case that had gone forward? Like, I think we just need to make sure there's some clarity so that the respondent understands what's going on, because, you know, there can be, you know, they can request an appeal of it, so of the denial of the opportunity to go forward. So I think it's going to be important to make clear, like, is.
Well, I understand. If that's the case, then we'll make a decision on the application the way it stands. Is that what you're saying, Paulette? Make the decision on the application, well, how it stands.
You're making a decision on it. So he's a new applicant.
Okay.
And again, like I said, you can look at, as you would for any applicant, if there are questions about honesty, truthfulness, and integrity, those are the questions you need to, if you have questions about that, to allow the respondent the applicant an opportunity to address any of those concerns. So I just want to make sure everything's kind of clear so that the applicant can understand and perhaps clarify for the commission any of these concerns. And, you know, if you think that the applicant needs more education, I mean, that's at the discretion of the commission. But with respect to truthfulness, integrity, et cetera, if there are questions, and it sounds like there may be questions, afford the applicant an opportunity to respond to whatever specific question you have that goes to truthfulness, integrity, et cetera.
Excuse me, if I could just,
You know, again,
I haven't been able to locate under his credentials the information that Mr. Trojanowski was referring to. So I just wanted to let the board know. I don't have that. I don't have that proof.
I'm going to look it up because I might have it in my records.
Thank you.
you know,
So,
again,
looking into the case here, he talks about how he was trying to get in touch, but on that November 7th hearing that he didn't show up for, there was a letter sent out where he had 15 days to respond against the decision that was made. And there wasn't a response.
So is that relevant? So what?
I'm just putting that out there because
Okay.
they're asking about the response time, and I know with this case there's been lack of response on his end.
But keep in mind, we had the hearing, there was a decision. So that is now moot, if I may. His lack of response, the concern about that. And does that go to truthfulness, integrity, competency? I mean, we had the hearing. He didn't show up, the decision was made. So that question about him not cooperating or responding is now moot because the commission did hear the case.
Yeah, and he's also saying that the commission has, you know, everybody has access to all of this on the record. They don't. I mean, I have access to it. Paulette, you have access to it. In the past, Kelly had access to it, but the commission doesn't have access to the base where all these documents are held. Just for the record, putting that out there. Because I know he's saying that you guys all know what he's done, and there really isn't any proof in there that there was a payment that made the consumer whole. Not that that was.
I wasn't a part of
he's
the,
saying
yeah.
that it was and that he sent it in, so, but it's not there.
Right, restitution was not part of the case. So let me just find that document that he had sent. And so in the meantime, if the commission has questions related to honesty, truthfulness, integrity, I think this is an opportunity to hear from the applicant, but I think you need to ask him some specific questions that goes to that.
I think we did that. We did that. We asked those questions the last time when he had the hearing, when he was our last hearing with him. So do we have to go through all that again?
Yes, because it's a new application. So if you have a question that's holding up a decision for him to move forward, if you have concerns about that, I think you should give the applicant an opportunity to respond to that.
you know, if I may say, you know, I did miss the meeting, and I explained to you why. Okay, and I feel that there's a feeling here that number one, I was dishonest, and number two, I was flippant about the commission's duties and responsibilities, neither of which is the case. Okay, and I know, and I can provide the information to Ms. Anand regarding the documentation of the payment. Okay, so the issue of my integrity and malfeasance and everything is not in question anymore, because I provided the information, and I'll provide it again because I have copies of the same information. So it seems that the commission is upset because I missed the meeting, and they feel that this is you know, a moral break that is beyond reproach. And I don't, I feel that if I didn't respond within the 15-day period from the November 7th meeting, I did respond in December, and I was going through a period, with some other issues going on in my life. So I don't understand why the commission doesn't take that into consideration. I don't understand why the commission doesn't take in 35 years of a career. I don't understand why the commission doesn't, even though you all as commissioners individually don't have access to the information, the state of Connecticut surely has information. Kelly had information. Ms. Anand has information about what went on. So, the commission rely on these folks to give you the information to make your decision. But the fact is that it's not a question of not having integrity and honesty. And, I've had up to 15 agents working with me over the years, okay? This is about me missing a meeting. That's what it's coming down to, okay? Because there's no issue with malfeasance as far as I'm concerned. It hasn't been proven. I proved to you that I paid the money to the person, okay? So as far as I can see, that would be off the table. I apologize profusely about missing the meeting, but, I had certain things I was going through at the time. And so for the commission not to, even back in December of 18, to deny me an opportunity to present my case, I think was unfair, because even though I missed the meeting, okay, you all are the ones that make the decision. You guys are making the decision on my life and my livelihood, okay? It's one thing if there was a proven case here and you could say something, but this is not the case. I've a 35-year history, and I miss a meeting, and now I'm forever, marked with the scarlet letter. I don't think that's fair, and I don't think it's right.
If I may, Mr. Trojanowski, I just want to address the one thing, which is the missing of the meeting. Just so you know, I mean, we're required under the law to provide due process, which is notice and an opportunity to be heard, and you were afforded all of that. I know you disagree, but you were afforded all of that, and that was shown at the administrative hearing. So that now, to me, is a moot point. I think everything else that you said, the commission has heard, and now, they have to decide and make a decision about your application, but you did get due process. That was absolutely clear at the hearing. And again, you disagree, but whether you disagree or not, that's not the truth of the matter.
Well, Mr. Chairman, are we ready for a motion?
There is something that just came on the screen here. Are you looking at this? This is a People's Bank. I'm not
This
sure.
is what Mr. Trojanowski had sent to us to show his proof that he had deposited monies that he believed was owed to the complainant in the matter that was heard by the commission. That's what he provided to us, and that's what
I'm just looking at some, I can't do what this means to me. Does anybody have this all on their screen? You understand this?
I don't.
There should be two things there. There should be a deposit slip in the name of Margaret Gorlow with the account number to People's Bank. And then there should be a deposit slip with the account number on it showing the deposit to that account. That's what that information is. Okay? And to backtrack a little bit here, I'm not saying that I wasn't given due process. But the opportunity to present new information as per the letter of December of 2018 was, to my mind, the point where we could have scheduled a meeting, I could have brought this information in, and we could have resolved it, I believe, to the commission's satisfaction at that point. And at that juncture, I had new information that the commission didn't have, and so therefore, that's what I'm saying. I wasn't able to present at that particular time.
I'd like an explanation for the delay in returning the deposit to this individual.
There wasn't any delay. The handyman that took over for the woman, they notified me on March of 2016 that he was going to start to handle the property directly. Okay, so I deposited the funds right then, within a few days, and that was it. All the other funds that she got went directly to her account. As I said, they were Section 8 direct deposit.
So let me understand what you just said, so it clarifies, okay? So you're saying a handyman in her home at 9 Chandra Drive told you that he was going to start handling the monies again?
Yes, that's right. As a matter of fact, he was handling the property before I got involved. And then apparently he got busy, so he asked her to get a property manager. And that's at the juncture where I became involved.
And so just on his word, you proceeded, is that correct?
I'm sorry, I didn't hear
that. No
POA,
no nothing? You didn't have a
POA? This was her guy, her handyman that was involved in helping her. I had nothing to do with him. He worked for her for years and years and years, and I think around that time he got busy with other work, and he didn't want to be involved. Plus, at that particular juncture, there were 5 out of the 6 units were vacant, and one house hadn't been rented in 6 months, so she was in danger of losing her insurance. So I just presume, I don't know, but I presume that he didn't have the ability or the time to rent these units up. And when I got involved, I had to rent them up, and I had to make sure that they were up to par with Section 8. There was a lot of violations in the various units that had to be straightened out in order to pass the Section 8 requirements. So he was there before, and then he was there afterward. Which is not unusual, actually, because a lot of times when folks are having problems with their property, they call in a broker or somebody to fix it, and then once it's running, they go, "Oh, well, that's okay. I'll handle it myself." So to me, it was a typical situation.
What was the whole amount? I mean, $1,750 was returned back. Was that the full deposit?
For
what was the deposit?
$1,750 was, I think, I don't have the information in front of me, but there was a portion of that was security deposit, and a portion of that, I think, $400 of it was the tenant portion of the Section 8 lease. I think the lease was like $1,500, I'll say. I don't recall exactly, but I'll say the rent was $1,500, and the tenant was required to pay $400, and the Section 8 paid the balance.
Any money kept? Did you keep any money for management and for your fee? You kept any fees?
What's that?
Did you keep any fees? Did you keep?
I didn't. Earlier on, I charged her for, this was back in September, I charged her for some rental fees for 2 of the first units, But in the end, you know, it just, she had gone into the hospital in January, and so I couldn't get in touch with her for the whole month of January, and I didn't know where she was. So, you know, in the end, I didn't take any fees. I just put them in there, and, you know, that was it. So I actually lost money on the.
But did you take any? In other words, let's say did it start off at 3,000 deposit and 17 went for her, or this by that? I mean, how is this breakdown? What was the maximum amount? I want to know where the money went to. How was this divided
Well,
up?
the money went, as I said, most of the Section 8s were direct deposit. Okay. Any overage like a tenant portion, for example, would go directly to her or for repairs on the property. You know, there was you know, thousands of dollars. The apartments had to be painted. The plumber had to be there. There was a furnace, water heater, and a bunch of other things that were you know, plumbers and painters came in and did work.
I need clarification again, excuse me. I need clarification again on what you just said. The money went where and then to her?
The money.
Where did it go first?
Section 8 funds go directly into this account that she had. It was a direct deposit. Section 8 does a direct deposit. They don't give you checks anymore. So as the owner, there was one tenant in there that was not a tenant, that was not a Section 8. That was, I think their rent was like $1,200, and that's the funds that we used to do the repairs on the house. That was the first tenant that went in there in September or October of 15.
Did you get that approved by her that you could use that money to improve?
Yes, I have a management agreement that delineates that she signed off on that. It says that, you know, repairs will be paid out of funds from collection of the rent. But like I said, you know, the bulk of the funds went directly to her through Section 8.
Do you have access to his or her account?
No, except for the deposit. That's the deposit.
Let me ask you something. How many different accounts do you operate? You have an escrow account, right?
Yeah, of course.
Yeah.
Of course. I have an office account, an escrow account, sure.
So you have 2 accounts.
Yeah, absolutely. And I prefer not to do, you know, to handle the funds into the account because it's just gets, you know, harder to handle. So I was happy to put the money in to have Section 8, get a direct deposit. That's less work for me. It goes right into her account. It's all verifiable and direct to her. So.
And you keep the security deposit in your escrow account, or do you turn it right over to her?
Do I say that again?
In other words, deposits. And do you security deposit?
Yeah.
Now what?
With the owners on security deposits, I give them the security because I don't want to be responsible for the security deposit. So they get the security.
Where did you get your management fee from? How did you get paid? Did she send you a check for your management fee? Did it come out of any accounts or anything directly? How did you get paid for your management fees? Curious.
The beginning, the first tenant was the one that I actually collected rent from. Okay, the others were directly deposited via Section 8. So I took the management fee again for the management agreement for you know, repairs and expenses. I can provide the management off on as well. Huh?
What was your fee?
I think she was a tough woman. She negotiated me, I think it was like $65 a unit or something, less than 8%.
All right, any other questions you have? All right, we ready to make a decision?
Fee had to do with a monthly fee, which I think the total was about 3 something, maybe 325. That's for 5 units. I didn't charge her for the other unit that was already rented, and then whatever the rental fees. That's all my fees were that came out of this property. And I didn't even get all that because, like I said, I did 2 of the rentals and then 2 rental fees out of that, and then because the house needed some work, and then the handyman decided to come back into the scene, and I just let it go.
That's what I understand. So are we talking now only about this deposit as being the money that was improperly accounted for? Was there any other money that was not properly accounted for?
That's all that she was due. The funds that were deposited, that's all she was due. Again, like I said, she was getting the direct deposit from Section 8. So. It made it easy for me because Section 8 sends her the check. I don't have to deal with it, and so on.
How did you receive your fee? And when you received your fee, what did you do with it?
What did I do with my fee?
Yeah, what did you do with your fee? Did you put it in a bank account? Did you cash it? What did you do with it?
Well, I used it for expenses as I would normally do.
So I ask again, did you cash it or did you put it in an account?
I probably put it into an account.
And what account would you put it into? Do you have
A business account. As a commission and fees.
I can ask the department to make sure I understand this. Mr. Trojanowski said this is the only fund that we've been talking about. This is the only funds that were based on the fine he paid. Is that the case? Is it just because these were not paid on time, or were timely paid, or what was the issue?
I'm not clear on the question.
I wasn't asking you, Mr. Trojanowski. I was asking the department.
The issue was the timeliness under the statute.
That was only these deposits. Again, this deposit.
Based on that complaint that went before the commission. Yep.
Well, didn't the complainant hire an attorney and that's how we got the complaint? That she hadn't received the deposit?
Yeah, she had hired an attorney and that's how the complaint came to the department. The attorney had filed a complaint on her behalf.
But let me say this too, that the attorney was hired before because because again, the fellow that was doing, that took over was not really, he was a handyman. So the attorney got involved subsequently just to handle the property from the financial side. She didn't hire the attorney to, go after me. He ended up, he was brought in to handle that anyway. That's why I say I was in contact with him and continued to work with his paralegal through November of 16, providing them all the documentation for leases and so on.
In the department, we don't, we don't know, the history or the relationship or the reason why the complainant had initially hired an attorney, but we do know, the only thing that I can offer on that is that it was the attorney who filed the complaint with the department with respect to the monies that were owed.
Was she in yeah. Did the probate court assign this attorney to her?
That's not relevant. We don't have any information on that. So it's not relevant to how we would process a complaint or go forward with the case. So I have no idea.
How soon after the other lawyer came forward with a complaint that did he pay the amounts?
Did he pay it? Up until the conclusion of the case, I had no information to support that he had paid the monies owed. But again, restitution was not part of the complaint. Typically, the department does not make a complainant whole because we don't represent the complainant. We always say to a complainant, if you want restitution, you would need to go to court for that. So again, restitution was not part of this case.
We need to make sure we understand. Oh, this is all we've got. We need to understand exactly what these bank statements show, right? We've got a deposit slip which has no amounts on it, and we have a, I guess, a banking receipt which has got 481 and it's like what 1200. Both of those are February 16th. We don't know what year. So I guess I'm having trouble understanding exactly what does that mean.
If I may, so what is the concern about the, is it restitution? Because again, we don't represent the complainant, so any case that I would bring is not about the complainant being made whole. It's about what the violations are in our statute. And again, the department, not the department, the commission had ended up issuing a civil penalty of $2,000 because, you know, we were capped in our statutes. Civil penalties don't run high. It was a $2,000 civil penalty for the allegation that was the finding against the respondent. So, you know,
But you're saying it's not relevant whether or not it was ever paid.
Not for our case, it's not, because we always say to a complainant, if you want restitution, you need to go to court. What's relevant at the time of a case coming forward is, was there a finding that the individual, and in this case, failed to remit within a reasonable time monies owed to a client, or in this case, the complainant. That's what the case was about, and there was a finding by the commission that he did not, hence the civil penalty and the revocation of his license.
I think, and I know where you're going with this. I think why we're asking these questions on it, I think we're questioning obviously is the honesty or integrity here, and that's part of what you've said. This is what he's applying for a license for, and he could be denied for. So I think this is, and I realize that we can't go backwards at this point, but I think this is what we're examining. Am I correct by saying that?
I totally agree. I mean, you tasked us, Paulette, with that, or you asked us to get definition on that. And that's where I find the relevancy here in our question, our just recent questioning, is to that end, honesty and integrity.
My concern too is that if we were to grant him a broker's license and then subsequently have someone come back and say that he never paid never accounted for that money, that wouldn't look so good for us. So I really think we should know whether or not those funds were repaid or were properly accounted for in the end.
I think one of the things also, there's probably more of a comfort in a salesman's license than a broker's license, but coming in as a broker's license, I think we've got to, it's a thing that we have to examine carefully. So with that, for a while, with that, we're ready to make a decision here and vote. First of all, any more verifications?
Would it help any if we were to get verification that the funds were properly accounted for in the end? I mean, I don't know if it's possible or not, of course. But would that help anybody?
Didn't
or
we?
not?
Yeah. I'm not
So,
sure. Go ahead.
So you are making a decision on my veracity, what this is coming down to, correct?
We're making a decision on information that we have on you.
Right, and whether I'm truthful or not is really what this comes down to.
Honesty and
okay.
important factor. Yes, we just discussed that.
Okay, so right. So the information that you have is an allegation, and then I told you what happened. I paid the fine. There isn't any other civil action against me regarding this matter. But yet you want to continue to investigate it in the hope to find something, or, I mean, this is, 2 years this is going on. And again, it's my fault in the beginning because I should have gone to, I should have gone to that meeting, okay? And would have been, responsible. But again, to me, it delays me getting on with my life while you guys decide whether you're going to look good in front of, somebody or not. And the fact is that there isn't any other information on this in terms of, the lawyer suing me to try to get funds. So based upon that, and I paid the fine, okay? I do apologize for this. I've been forthright with you on everything. I have 35 years of experience, but it seems that you just don't want to believe me. I missed the meeting and there was a mistake, and that's what happened. I mean, all the information that you have is here, is available to you. And I'll get you a copy of that because I know there is a date on that deposit slip with the funds. So I'll get a better copy of that for you. I'll be happy to do that. But I mean, it just seems like the whole 35 years just means nothing, of what I've done before. I've explained to you that, I've been involved with the boards nationally and locally and statewide, all these kinds of things, but that doesn't seem to, carry any weight.
Well, and we're also here to protect the consumer. You have to understand that too.
Yes, you're absolutely right. You're absolutely right. And I am also a consumer. I'm a consumer of real estate. And so in terms of a functioning real estate broker. Okay. So, I mean, you could, as I see it right now, the evidence before you is that the consumer has not, there's nothing here. As I said earlier in the conversation, there is no malfeasance. How would you know that? Because there's no state, there's nothing. I mean, you can keep going back and forth, and we can delay this. We'll go into next year, and the year after, and the year after. Okay, but my life is going by. Okay, You know, I've with the past 2 years, I paid the price. Missing the income and so forth. Again, a 35-year plus career, and I don't understand why the commission is resistant. I mean, even I'm a real estate broker with 35 years of experience. I think you would give me the benefit of the doubt going forward to say, hey, we can rest our, hat on the fact that there's no civil suit against this person. He did miss the meeting. He paid for that. He paid the penalty. He paid for loss of income for the past 2 years. Okay. He's come before you. He's apologized, and he's provided information, all the information that I can.
I have a question for the department. Currently, Mr. Trojanowski does not hold a salesman's license or a broker's license. Is that accurate?
Yes, that is accurate.
Normally, in order for us to approve an application for a broker, they have had to hold a salesman's license, I believe. Is that accurate?
Yeah.
Would it make sense for us to consider his application for a salesperson at this point rather than for a broker's license?
Paulette has already said we cannot do that.
Mr. Chairman, are we ready for a motion on this?
Yes, I am.
Okay, so I move that we allow Mr. Trojanowski to sit for the exam.
What about education?
That's
Do you
a
want him
separate
to
matter.
take any type of courses?
Well, he would have to, because that's mandated by the DCP guidelines. So so he will have to go back and become re-educated, because the education Mr. Trojanowski has no longer satisfies current DCP guidelines. What we're talking about today is whether or not he can sit for the exam once he has received the appropriate education.
Fine, I needed that clarification.
Sure.
So I need a second for that motion.
I second it for purposes of discussion.
Okay. Discussion?
Since it was my motion, I'll just briefly say, to me, I can't see evidence of harm, and I can see that we did, that there was a penalty, and Mr. Trojanowski was penalized. He paid the penalty, and I can no longer personally, I don't see anything barring. I'm not seeing positive evidence of problems with, of his moral character. So that's what I'm seeing.
You're very consistent, Peter.
I respect that. Are we ready? All in favor?
Aye.
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 Oppose?
Aye.
Aye.
We're tied.
You need to break it back.
Did Lana vote?
No, I do not.
Can't vote.
Were there 3 in favor? What did Ted say?
Aye.
Poll them so you'll know. You can poll them and hear it.
I'm sorry, again?
You might want to poll the commission so you'll get a clear yay or nay for each commissioner.
I'm not sure how to do that.
Ask their name and they will say yay or nay.
All right. Linda, go ahead. You first. Oops.
Yes, unmute.
Unmute.
Yeah, sorry, a nay.
Ted?
Aye. Yay.
Amy,
No.
Peter,
Yay.
3 yeses.
Who were the yeses?
The yeses are Ted, Peter,
Morag.
Mo. Are you approved to sit for the exam?
Ben, are you gonna vote?
We just voted.
Are you going to vote?
I don't have to vote.
He doesn't have to. He's chair.
Chair doesn't have to vote unless it's a tie.
Right.
It's the only time.
I have a question.
I'm sorry.
The mandatory fair housing that we just passed, will that be part of the brokers?
No, not for a new licensee. Now, if he's going to sit for the exam, he's going to sit for the 60-hour course, because after 2014, I believe, you have to sit for the 60-hour course if your previous course was only 30 hours. And then I think he should, the broker's course as well, the 15 hours, because that goes right in line with keeping books and how to run a broker's course. How to run a brokerage. Excuse me.
So you're saying that this fair housing mandatory class is not included in the brokers, correct?
If you get licensed in this year, you don't have to take the mandatory classes.
Okay.
But there
Okay,
is,
so we just had to-
He would be for the next.
And I'm just going to say, the reason I'm asking is because because at the beginning of this entire conversation, one of the comments that Mr. Trojanowski made was not such a great section of town. And I think he needs some education.
I mean, you could put, I guess you could probably put anything on that you want. I mean, if you want to make it that he takes the mandatory this year, state it, I guess.
Paulette, let me ask you that question.
I would be in opposition to that. I think, we're going to treat him like every other applicant. And if the vote is for him to take the examination plus the 60 P&P plus the 15 broker, that would be what it is. If there is an exemption for new applicants for the mandatory course, we should not be applying a new standard to this applicant.
I think when in the P&P though, isn't it? In the P&P, there is some in one of the classes, fair housing.
There is some fair housing in P&P, yes, and there's also the law portion of the exam.
Right. So probably not in the depth you're thinking of, Linda, but I can understand where you're going with this. But I also understand what Paul is going to with this.
I took it not that long ago, and it was quite robust, at least from my perspective, and it was surprisingly lively.
I have a question. Is if Mr. Trojanowski takes this course and gets his broker's license, I think this was answered previously, but I just want to reiterate it. There is no way for us to monitor him.
Certainly, I mean, the DCP can audit his book, his office, correct?
We're not, unless we
can't make it a contingency, right?
No, we cannot. And, I would not recommend that that's something that we, look to do.
That's never been done in the past where you would.
If there's reason to believe that something should be audited, that's when that happens. But on this new application, it's not something that I would recommend that we would,
I think
the department would just go and, audit.
Maybe Kelly can, I think in the past, if someone had a license and we fined them or whatever to it, I think we've gone back and had certain restrictions that they had to, for 6 months, we monitored them or something. Am I correct, Kelly? You can shake your head. Either way. So.
That's something we could do? I'm not saying no, but I mean, I think we have done in the past too. And if it was a very limited review.
But these were
But that was
licensed.
different. That was an existing license. This is a new license. So there is that
The new
difference.
license, exactly,
That's why-
exactly. We should not be adding any new requirement that's not in the statute for the new license.
Okay, so what you're saying is you aren't waiving anything. You guys are gonna hold them to what the requirements are today to get a license.
That's correct.
Although, yeah, it's difficult if they're yes or no, kind of. Okay, anything else? We have passed that decision.
So just for clarity, can you just please just reiterate what the commission has decided so that Mr. Trojanowski is clear on what it is that the vote is?
We have approved that Mr. Trojanowski can sit for the real estate broker's license. Current and current criteria. Yes, to me.
And the current criteria being, just spell it out, please.
60 hours P&P, 15 hours of brokerage.
Mr. Trojanowski, are you clear on that?
Yes, question. Does the, so 60 hours of the P&P and how many on the broker? 15?
15 hours.
Okay. Now, I've already had the P&P 30 hours, so do I need to take the whole 60 hours?
Whole thing.
Okay. Okay, very good. I appreciate the commission's decision.
Good luck, Mr. Trojanowski.
Thank you.
Thank you. Okay, just a couple quick things. Remember, you also received the you also received the Real Estate Commission schedule for next year. Everybody get it? All right, put in your calendar. And also I want to say a couple things.
Ben, did Cindy has a question.
Oh, I'm sorry.
Yeah, Ben, just for clarification, when you passed the course earlier, was that inclusive of the train the trainer requirement? It was part of our presentation. I just wanted to be sure that that was inside the vote. Paul, you're nodding yes, so.
Yes, I am, yes.
No, I'm nodding saying that's a good point to make sure it's clear.
All right.
I think that was clear.
Did you hear me? Yes? Okay.
All right, everyone, just checking. Okay. Thank you.
Thank you, Cindy.
I wanted to thank everyone that was involved in developing those two courses. I'm sure it took an enormous amount of time, and it's appreciated.
Can I ask how is the commission going to notify the schools and notify the schools of when training is available?
Joe? Joe?
Sure, that's directed to me.
I
am going to say, I think we will probably, I'm probably going to get back with the education committee and ask about the train the trainer.
And the training's only for the CTR course, is that correct? The required training? The train the trainer is only for the CTR course, not the other course, is that correct?
That's the way I thought it was going to be.
Yeah, I would hope the instructors know the subject matter, the first mandatory course.
Agreed. I just wanted to clarify.
Right.
I mean, there's been talk with the education committee on both sides, train the trainer or take the course, at least take the course, because there's a lot of.
But somebody's got to be able to give the course. If you have to be an approved trainer to give the course, then there's going to be nobody to give the course. You know what I mean?
Yeah, I do know what you mean.
Mm-hmm.
So I'm going to have to check on that to see if.
Any suggestions, Lana?
Yeah, and I'm happy to work with Lucy. We're willing to give any resources necessary to do it. I can teach it. You know, we've got members of our diversity, equity, and inclusion group that are able to teach it. We're really ready to step up and offer it as often as you need it.
I just think it's needed pretty
CTR.
quickly.
Yeah, and we can do it right away. I mean, we've been working with this course for several months, so there's not a learning curve, except as Joanne mentioned, we think we need to have a really specific preamble to the course, so everyone starts from a positive place.
Yeah, that would be great if CTR stepped up like that and did the training on that course.
Yeah.
Much appreciated.
There's been a lot of inquiring about when these courses are coming out. People are, because I said the commission was meeting today, this week, I'm probably going to get about half a dozen emails anyway saying when are they going to be available. So are they ready to roll
The
out?
first step is going to be to notify all the schools of the train the trainer and how they can sign up, when it's available, that kind of thing.
Okay.
But honestly, if you wanted it as early as Friday, you know, we could be ready to do it if the education committee was ready. So we can fast track it. CTR can provide resources to fast track it as fast as you need. So there doesn't need to be a delay. You know,
So
obviously it's a delay having this extra step, but should the education committee want to proceed quickly, we're available to do quickly.
So with that said, I mean, if you're saying you're available Friday, not that it's going to be Friday, we have to have time to notify these people and get that on their calendar, because that will be a live virtual class, correct?
Yeah. But Jill, I just wanted to let you know, timing wise, for people who might have any time period, if they need nights or if they need weekends or during the day, to get the course out, you know, we don't want availability to be anything that stops it, since that's an additional step. You know, so whatever your group decides is necessary to move it forward, we're available to provide that resource. And whatever timing. I just gave Friday as an example because it's so soon, but if there are people ready to go, we're ready to go. So just let me know.
Yeah, gotcha. I guess, you know, I can talk to you about that, Cindy, and also see that it's ready to go. Because I know at one point there were still slides going, or still videos going in. I don't know if it's all complete.
Yeah.
Now.
We did finish the last two. Johanna Hayes has a very compelling story that we learned when we first endorsed her. You know, we talked to her a lot about real estate. So one of the homeowner stories we wanted to include was hers, and she wanted to wait till after the election. So we were just hoping we'd have a little bit of space to add Johanna specifically into our what their homeownership experience has been like and why that mattered to her family. Portion of it, but the course could go without that and that just be added later on if necessary, or it could just go the way it is, but it's good to go.
Okay, thank you.
And can I,
this is
then I hate to do this because I know everyone wants to invite Alana. I feel anyway, one of the questions that was on the agenda for today, Ben, I didn't know if you weren't going to cover it. It was actually from one of our local associations. It was related to their question about if they can offer a discount for people who take classes through their school. We don't care at all. This is not a CTR request. I thought it would be an immediate no. But when I asked the question, they said they put it on the agenda. So I don't know, Ben, if you wanted to do it at a later meeting, or you just wanted me to put out there that we had the question and it wasn't an immediate no from staff, and instead went to all of you to decide if that was or wasn't okay. It was the second thing that was on your agenda that was noticed out.
Yeah.
It's no hurry if you want to just say that.
Yeah.
And it's not our issue. It came from one of our boards.
We'll put it off to another.
Okay.
Okay, to another meeting. I want to talk to the department about that too.
Okay.
All right. Well, Lana, unmute. I don't know if you can hear me, but anyhow.
Okay, I'm unmuted.
It was so sad when I found out that you're going to be leaving us after 21 years. And I'll tell you, anybody who put in as much into the commission as Lana has. She's been great. We've been together longer than most marriages, by the way, probably. He's been super. He's done so much for the commission, especially the educate. We've put everything, to be honest with you, always on Lana. Lana carried us through on this education for 20 years. And I'm going to miss you terribly. And we're getting,
Thank you. I'm going to miss you as well.
the commission is going to miss you. The state's going to miss you. Very good.
Thank you. Thank you. It was a real education, and I had the pleasure of meeting and working with everyone here.
And if I may,
before-
We definitely will miss you. You've just been an anchor and so solid and very helpful to all of us.
Thank you.
And on behalf of the
And a good
department, Lana, I just want to say that I've only been here 3 years. 3 years, wow. And it's just been such a pleasure working with you, hearing your insights. And I know Kelly probably has so much to say, but we're certainly going to miss you. And we really appreciate all that you've done on the commission, your work, your integrity, your commitment. It definitely shows through the many years that you committed to the commission. And I just wish you all the best going forward in whatever it is that you're going to be doing. All the best with your family, and I'm sure you're going to just be great in your next adventure.
Thank you. Thank you, Paula.
I have to say
And you
that
earned every dollar you you got.
there's no way, Lana, that I could have taken on the education piece without you being there. And I hate to say that in front of Jill because Jill's not going to have you. But honestly, because of you, I think I am a better instructor than I could have ever been, because you've always held the schools to a high standard. And I learned a lot because of that. And so I thank you, because I'm succeeding as an instructor and I'm enjoying it tremendously. But I do think that it's because I truly learned so much from you in reviewing those courses.
Thank you. I'll pat myself on the back.
Well,
Thank you, Kelly. That's really nice.
Alana, I know it's going to be very difficult for me to continue without you because I always look to you as the one who would, tell me what was going on and that you were paying attention. And that in terms of the education, I mean, you were the education as far as I was concerned on the commission. So it's going to be really, and as a friend too, I really will miss seeing you 4 times a year. I hope though that you will maybe come back once in a while. Particularly on Zoom, you can just pop your face up so we can see you and say hello to you. I wish you the best. You are the best.
Thank you. And I know where you live too.
I'm right. Come and see me anytime.
When we used to do things as a commission outside of the building.
Lana, I just wanted to say that I'll miss you a lot. When I came in as a newbie, I don't know a few years ago, not that long ago, it doesn't seem, but probably is. You were very welcoming, and you made me feel like there was someone there that really was, as Morag put it, an anchor, somebody that was going to have the knowledge that I might need to to be informed. So we'll miss you a lot.
Thank you. Thank you. Well, I'll stay in touch.
Lana, thank
so
you.
much.
I'll just echo that. It's really wonderful to have committee members who have been here for so long that they're a bank of knowledge that we can reach into and try to understand, what's been decided in the past and how does that shape where we're going and the decisions we make going forward. And working with you this last round on the education group, it's evident how long you've been doing it, and you're picking up on all these little mistakes and everything, and it helps just make a better product for all the instructors and all the licensees that have to learn it. Thank you.
Welcome. Thank you, Amy.
Mr. Chairman, I have one request, and that is if when we all can get back together again in person, can we have a luncheon for Lana?
Absolutely. Absolutely.
That would be nice. I would like that. And the best thing.
Sometime in the future, Lana.
Yeah.
The best thing, Ben informed me, I'll always have the title commissioner because I've been there so long. So I can put that on my my gravestone.
Yeah, that's your title.
Oh, geez. Not too soon, I hope.
No, no. I hope not either.
Yeah.
Thank you. Thank you all. I'll miss you.
We'll miss you too. Before I start crying here, I'm going to adjourn the meeting. All right? So thank you. Thank all of you for participating today. It was a long one.
Excuse me, I'm sorry to interrupt. It's Fran from the CE shop, and I just wanted to just circle back before we adjourned and find out, I don't know who to address it to, but what would be our next steps moving forward with wanting to offer the mandatory course asynchronously online, because we were trying to get information and we didn't, and then Ben, you said it's kind of late. So where do we go from here?
I would say take it to Jill.
Well, again, I'm going to reiterate what I said earlier, that the case, that the class, I can't even talk anymore. The class was written to be in a live classroom or via live virtual. So it's the way it should be presented, to incorporate discussion and
right
with the attendees, with the instructor, and there'll be a train the trainer, so you'll get information there, and there'll be information coming out. There'll be a letter coming out shortly, so we can get the ball rolling. And when they said that, when Ben said he was late, Ben's not late. The whole education committee rolling out these courses was late because of COVID and trying to learn a new way of getting this all done. So that's why we were late. Everything's late.
No, understood. And just, I mean, I would comment, I know you had said earlier that live virtual is online, but, and Miss Annan, correct me because you know the rules. You are the queen, but is there a rule that states that only one type of online course is allowed? Because I didn't see them, but I'm certainly no expert. So I understand the class was drafted to be, it's being viewed as being more effective to be given online virtual, but do the rules allow that online virtual can be the only online delivery modality?
Well, I mean, we're treating this like our PMP class, like our pre-licensing classes that are delivered live or now as of COVID, I guess, at the beginning of the year, that was live virtual.
Right. Well, and I understand, I mean, certainly because of COVID, we're all in the same boat, but that means we also all understand the need for online or not in-person courses. So I just want to understand how asynchronous can be, and forgive me, it's just my choice of words, but kicked to the curb in favor of something else unless the rules state that that's the case, and I just don't know that.
The law does not state that. So there isn't any rule that specifically says live virtual is the only way to provide an online course. However, like I said before, the discretion belongs to the commission, and as to, you know, which courses they're going to approve.
Right. And so
Course providers.
I'm sorry, because I know you guys have had a long meeting and I apologize. So I will wrap this up as quickly as I can. I just don't want to miss the opportunity to understand. So I understand that that they have the discretion, but does that translate to then unilaterally making a decision that is not good for all providers? Because we have been a provider in the past with a more than adequate track record, and now it's our opportunities being clawed back, and I think we're just struggling with that a little bit.
I understand that at some point that the course providers would submit, I guess, an application to be a provider for the mandatory courses, and I think at that point is where the commission would make a decision as to which courses they're approving. And I know that your position is probably that you don't want to wait until that late a time in which to then request an appeal of that decision. And I totally get that. So, you know, I don't know what the commission wants to, if the commission has a response to that, whether the commission's response is going to be, you know, we're going to wait for applications, or is there something that the commission would, if you're proposing something that the commission would take into consideration maybe at another meeting? I don't know.
Well, are the outlines I saw on this morning, the current outlines were not yet available. Are those outlines going to be made available? And if so, when? So that's one question.
Fran, you're talking about the 2 mandatory classes, the outline of those?
Correct.
Okay, so those are basically complete, but they're going to be rolled out with the fair housing is going to be train the trainer that's going to be rolled out in conjunction with a class, and the other mandatory will come out. I mean, there's going to be something sent out probably the end of the week.
Okay. All right. I appreciate everyone's help and patience as I tried to get clarification. Thank you so much.
You're welcome.
Thank you, Fran.
Thank you. Okay. Meeting's adjourned.
I love spending all these hours with you